This is part 8 and the conclusion of property. We're going to begin, we spoke last time about easements. We're going to begin this time talking about covenants. There are two types of covenants, real covenants and equitable servitudes. These both restrict the right to use land. Run with the land, subsequent owners may enforce and or be burdened by the covenant or servitude. A real covenant is where damages are sought to enforce the covenant. An equitable servitude is where an injunction is sought to enforce the covenant. To run with the land, the covenant must be in writing. There must be intent for it to run with the land. The covenant must touch and concern the land. There must be notice of the covenant and privity between the parties. Horizontal privity is privity between the two estates originally creating the covenant. Vertical privity is privity between the owners passing it down. Again, with the writing for a covenant must comply with the statute of frauds. The intent in regards to the covenant running with the land must intend to have the covenant run. Any language such as, quote, and heirs and assigns constitutes an intent that it run with the land. Regards to touching and concerning the land, this is the benefit or the burden affects the promisee and promisors as owners of land and not individuals. Under the modern trend, this is not important. However, it is valid unless contrary to public policy. When considering whether the covenant touches and concerns, just look to the benefit to the other landowners in use and or enjoyment of the land. Covenants to run with the land, there must have notice. This goes to the burdened estate only. It must be, the notice can be constructive, such as recorded on chain of title. It can have actual notice, where they're told of it directly, or inquiry notice. That is a duty to find out. Constructive notice, recorded on chain of title. Actual notice, they directly are told of the covenant. Or inquiry notice, that is a duty to find out. Again, looking at privity. To run with the land, you must have privity. Horizontal privity, this is the burden again. You must have privity of estate at time of agreement. It's a shared property interest, and that's between the parties creating the original covenant. Modern trend, this is not as required as it historically has been. That's the modern trend, at least. Covenants terminate, like easements, with a written release, merger, abandonment, a bona fide purchaser for value without any of the notice above. Looking at water rights, moving on from covenants, looking at water rights, this is the riparian rights. This is where the water belongs to those who own the land bordering the water. They must, and under riparian rights, those owners must exercise reasonable use. They are liable to each other for unreasonable use and or interference with others' use. So if your neighbor upstream siphons off all the water, you're liable to the people downstream, or the other people that rely on that water. Now, that is riparian rights. That is mostly eastern states look to that. In western states, they mostly look to prior appropriation. Here, water belongs to the state. The right to divert the water and use can be acquired by an individual regardless of location. In regards to surface water, this is water that derives from rain and or snowmelt. This is not part of a waterway, and this applies in half of states. You may make changes and or improvements to land to combat flow of surface water. The other half prevents alterations. This is the natural flow theory. Now, most states have mitigated this to reasonable changes to water flow. So again, you have a divide between can make improvements. In the modern trend, this is is you can make reasonable changes to water flow. Looking at support rights, you have a right to have land supported in its natural state. You are strictly liable for damages adjoining land caused by excavation unless adjoining land excavated in a way that contributed. Subjacent support, you have a right to support from beneath the surface. Owner of mineral rights is strictly liable for failure to support, liable only for negligence for damage to improvements built after the conveyance. And that completes all sections of property.